Hi, my name is Rob Barnett. I am a teacher and a lawyer, and I have created this series of videos to talk to you a little bit about criminal law. What I would like to do in this video is give you a really broad introduction to the main things that we talk about when we talk about criminal law. And then in future videos, I'm going to dive a little bit deeper into some of the topics that I introduce here. There's two considerations I want to mention before we get going. The first is that this video series only focuses on the substance of criminal law. In other words, what are the crimes and what are the defenses? This video series will not talk about criminal procedure or constitutional protections, although I will be making another series of videos to talk about that. The second consideration is that this entire series is very general. Probably each bullet point I put up in every video could be an entire hours-long discussion or a law school class. If you are interested in anything that I say and want to learn further, I encourage you to do so. With that in mind, let's get started. I want to start by talking about the requirements of a crime. Every crime has a couple of the same things in common. The first thing that every crime needs is called an actus reus, or what an actus reus really means is a guilty act. There must be some act that is criminal. The act and it also has to be something that's voluntary. It has to be something that you do, or in some cases that you fail to do. There are a couple elements of this act that we want to look at. Sometimes an act is criminal because of the conduct. You do something that has been outlawed. That's called conduct. Sometimes an act becomes guilty because of a result. For instance, homicide. The result of killing someone must occur. Sometimes we can have an act that is criminal because of attendant circumstances. An example of this is statutory rape. That act becomes criminal when there is the attendant circumstance of a victim being under the age of majority. So that's the first thing you need, a guilty act. The next thing you need is known as mens rea. And mens rea, we can think of that as the guilty mind. In other words, for something to be criminal, there has to be some sort of intention or mental state that motivates the crime. We can think about mental states in a couple ways. First is something that we call general intent. General intent means you intended to do the act. General intent is just you intended to do the act. And there are some crimes, such as arson, where all that's required is you intended to do the act. You intended to light a building on fire. You didn't really care what happened. All you wanted to do was that first act, and that's a crime in itself. There are other crimes where what's required is something called specific intent. And that means you intended not just to do an act, but you also intended the result. So there's act plus result. So an example of this might be burglary. The act is breaking into someone's house, but the intended result is to steal something. So there's both the act element of going into the house, but also the intent of stealing something, and both of those are required for the crime. When we think about different mental states that go with crimes, and as I talk about each crime, about required mental states, there are sort of four basic mental states that I want you to be familiar with. Again, we'll become more familiar with this by looking at crimes, but there's four mental states. The first one, I'll write those over here, is purpose. This is sort of the highest mental state on the hierarchy, but you did an act that was criminal for the reasons up here. That's what made it criminal. And it was your purpose. It was your conscious objective to perform that criminal act. A little bit lower down on the scale of the mental state required for a crime would be knowledge. In other words, you do something knowing that it is criminal. You do something knowing that it's criminal. So that's probably not as bad as doing something because you want to do something criminal, but you know it. And if you know something, that means you probably should not have done that. Third state that we talk about is recklessness. You do something recklessly. You do something without really care as to what the outcome might be. That can often be criminal. And then fourth state could be negligence. And negligence is not usually criminal. Criminal negligence usually you have to be pretty negligent, especially as compared to maybe a tort state of negligence. But there are some acts where you can be criminal for negligent behavior. And then in a couple cases, actually, and I'll make a little note here, there are some cases that actually have strict liability, which is another tort concept, which means if you did it, you're liable. No matter what your intention was, if you did it, you're liable. So those are two things required of a crime: an act and an intent. And the last thing that is required in a crime is some sort of causation. So if you do an act and results are part of what makes it criminal, well, there had to be some causation between your act and the results that occurred. You know, if I drive a little bit too fast and somewhere along some long chain of events in 10 days someone dies, well, they probably can't trace that back to me. So there has to be some sort of substantial causal link between the act and the results. And sometimes we think about this as in a but-for test. In other words, but for the act, the criminal result would not have happened. So these are the three requirements of a crime: a guilty act, a guilty mind, and causation. And as I say, when we get to specific crimes, we're gonna think a little bit more about each of those in those contexts. Let me just highlight for you next. These are the types of crimes I'm going to be talking about. The first type of crime I'm going to be talking about is homicide. This is a good crime for us to understand the whole criminal law framework. We can have intended killings or unintended killings. We have different rules for both of those, and that's something I'll examine in greater depth. Next, we'll talk about lesser crimes against persons. They don't result in death, but they can result maybe in serious injury, physical, mental, or emotional. We can talk about assault. We can talk about battery, rape, kidnapping. Those are offenses against other people. There are also crimes against property. There we've got theft, robbery, burglary, and arson. These are crimes that you don't commit against a person, but you commit against someone's property. And then finally, we have something called inchoate crime. And these are crimes, actually, where there doesn't necessarily have to be a harm done, or the act doesn't, the criminal person, the defendant, has not actually done something wrong, but they've maybe helped or planned to in some way. So we could think about attempt. Sometimes attempting to do something is a crime, even if you don't do it successfully. Being an accessory to a crime, helping a crime happen, can be criminal. You can have a crime of conspiracy, conspiring to do something, even if you don't actually end up doing that criminal thing, or you can solicit a crime. As I say in the beginning, I'm not going to spend time on these here. Each of these four general categories, homicide, crimes against persons, crimes against property, and inchoate crimes, will form the basis for my next series of videos. The last thing that we really talk about a lot in criminal law is defenses to crimes. Not only what constitutes a crime, but what makes a defense against a crime. There's two types of defenses. The first is excuses. And what an excuse means is, well, you didn't do the right thing, but we excuse you because of some other factor. There was some factor which makes the person who committed the act not morally blameworthy. So those excuses might be mental disorder. You probably heard in the news, not guilty by reason of insanity. Well, if you have a mental disorder and you do something, we might not want to hold you culpable for that. You hear about intoxication. So if you are drunk, it may not excuse a crime completely, but it may drop the level of the crime, or in some cases may excuse the crime. Infancy, juveniles are often held to different standards. Entrapment, if someone convinces you to commit the crime and then you do commit the crime, in some cases we will not hold you liable for the crime. You may make a mistake of fact or a mistake of law. Or if you're under duress, meaning someone says, commit this crime or I will hurt your family. Well, if you commit the crime, we may say, you shouldn't have done that, but we excuse you because you were under this duress. The second type of defenses to crimes is known as justification. And justification, as it sounds, means what you did was actually the right act. The law may say it's criminal, but for some reason it was right under the circumstances in which you performed the act and with the mental state that you had. So we can talk about defense of self or others. If you are defending yourself and you kill someone to prevent that person from killing you, we usually say that's justified. Defense of dwelling is sometimes a justification. I'm actually going to put defense of dwelling in parentheses because in some jurisdictions this is, in some it isn't. It's definitely a little bit more limited. There are a couple other justifications. Necessity, meaning you committed a crime to prevent a greater harm. Public authority, this has been in the news a lot. A police officer in certain cases has the right to shoot and kill someone, and we say that is justified. Of course, there's a factual inquiry that has to happen in those cases. And finally, crime prevention. You sometimes can say, I was trying to prevent a crime and I had to do something criminal in the process. We would say that's actually justified and you would not be held liable. And again, I will make a separate series of videos that talks more about excuses and justifications, but I want to highlight that here. The topics I've talked about even in this video really form the entire basis of criminal law. We have the elements of a crime, we have types of crime, and then we have defenses to crimes. So if I've caught your interest here, I hope you'll continue watching. Our next lesson is going to be about homicide, one of the most serious crimes and a really good place to start our inquiry.